So, these are the aims of these recorded lectures. I would like you to understand the legal context in which the UK's decision to leave the EU must take political and economic and social and cultural form. I would like you to be able to understand contemporary political and economic and social and cultural developments through that legal context. We will be considering the future EU-UK relationship and its legal forms, principally, as I record this lecture, the withdrawal agreement, more on what that is later, but perhaps one or more trade or other forms of cooperation agreements if those are forthcoming after I've finished recording these lectures. I have already had one experience where I wrote a version of this lecture the day before I was due to give it live, and then I had to rewrite some of it the following day. Throughout the lecture, I will be helping you to prepare for the assessment for the Advanced EU Law module by allowing you to reflect on what the Brexit example means and reveals about the nature of European Union law and its legal system. Let's start with the European Union referendum. On the 23rd of June 2016, the United Kingdom voted to leave the European Union. 72% of the electorate turned out to vote. Of those voting, 52% voted to leave. What I'm going to say now is based on a blog that I wrote with Professor Joe Shaw for Edinburgh's European Futures blog on the 23rd of June 2017, 1 year later. It would seem clear, 52%. The people have spoken. End of story. This argument may be beguilingly simple, but it does not feel quite right. Actually, there are many ways to unpick the argument. For starters, the UK tradition of holding referendums is of rather recent vintage. Referendums have been increasingly used in recent years, even on highly socially divisive and constitutionally weighty issues, such as Scottish independence. But they are not a really deeply embedded part of our constitutional history. So we don't fully understand how they fit into the overall scheme. Every referendum is different in terms of how it is organised and who can vote in it. More generally, referendums have contributed to the UK moving away, especially in the last 20 years, from the unitary Westminster model, which we may have studied at school. This model is admired all over the world. It is still held up as a historically quintessential expression of parliament-based democracy as opposed to authoritarian rule. Now, we are a complex and plural democracy. Significant power is devolved to elected parliaments and governments in Northern Ireland, Scotland, and Wales. Local government also plays an important representative role, especially in mayoral cities, including London. And since the 1970s, we have also agreed to pool or share sovereign power with the other countries of the European Union. Both before and since these changes, our constitutional system, like other mature democracies, has been based on a system of checks and balances. How does a referendum fit into this idea when it is based on a simple 50% plus one majority vote? A decision of this magnitude, which will change everything, shouldn't, we feel intuitively, be able to be made over such a short space of time, i.e. just one referendum campaign, by a simple majority of voters in a complex plural political system like the United Kingdom. In effect, the decision has overruled Scotland, Northern Ireland, London, and Gibraltar, which all voted to stay in the European Union. One way to make sense of why it doesn't feel right is to understand the nature of the group of people who voted, the demos. Many people who are most profoundly affected didn't get to vote. Nationals of most other EU countries resident in the UK, many UK nationals resident in other EU countries, and 16 and 17-year-olds. When we talk about the makeup of the demos, who we are, we don't mean our makeup in terms of how we identify ourselves, for example, as Scottish, British, and/or European, although that is important too. We mean instead understanding how the demos for the EU referendum vote was legally constructed within our constitutional setup, especially since there are several different ways of legally constructing electorates which are part of UK constitutional law and practice. Prime Minister May's government and Prime Minister Johnson's government too behave as if this particular demos is the demos. But the group of people who voted in June 2016 could legitimately have been constituted differently. It could have included, for example, 16 and 17-year-olds. They voted in the 2014 Scottish independence referendum. It could have included citizens of other EU countries resident in the UK. They vote in local and European parliamentary elections, and they voted in the Scottish independence referendum too. And it could have included UK citizens resident abroad for more than 15 years. This exclusion was tested unsuccessfully in the courts, and the inclusion of this group in the UK electorate for life has ironically been promised by the Conservative manifestos of 2015 and 2017, but not yet introduced. Let's talk a little more about the EU referendum campaign too. According to the Full Fact organisation, according to Full Fact, the independent fact-checking organisation, it's true that campaigners on both sides made false claims during the EU referendum campaign. Sometimes they even made false claims about the false claims made by each other. So, for instance, one claim was that house prices would fall by 10% immediately after the referendum vote to leave the EU. It's not true that the Treasury said that. The Treasury didn't predict that house prices would fall by 10% immediately after the UK voted to leave the EU. The Treasury did say something that sounded a bit similar. It expected house prices to be 10 to 18% lower than they would have been otherwise at the end of 2017-18. That wasn't a 10 to 18% fall from what they were on the 23rd of June 2016. It was a 10 to 18% fall compared to what they would have been in the parallel universe where the UK would have voted to remain in the EU. To be fair, many news outlets didn't spell out the difference clearly, and nor did Mr. Osborne, the then Chancellor of the Exchequer. It's also important to spell out the difference between the debate about the short-term economic consequences of voting to leave the EU, which created lots of uncertainties, and the long-term economic effects of actually leaving the EU and trading under different rules. Just because the Treasury's expectations about the immediate impact of a vote to leave were wrong, doesn't necessarily mean that its long-term expectations about different trading arrangements are automatically wrong. The extra money for the NHS was definitely a lie, though. And yet, Dominic Cummings, who was the author of the statement on this bus, has admitted that all Vote Leave's research and the close results suggests that Leave would not have won without that statement. The European Union's Treaty on European Union, which is one of the two treaties which establishes the European Union and sets out the rules by which it operates, has a procedure by which a member state may leave the European Union. This is in Article 50 TEU. Article 50 provides that any member state may decide to withdraw from the European Union in accordance with its own constitutional requirements. The member state that intends to leave has to formally notify the European Council of its intention. The European Union is then formally obliged to negotiate and conclude an agreement with the departing state. The agreement has to be concluded in accordance with a procedure set out in the treaty, Article 218 TFEU. The European Parliament has to consent to the withdrawal agreement, and the Council has to conclude it acting on a qualified majority. Article 50 provides that European Union law shall cease to apply to the leaving state on the date of entry into force as specified in the withdrawal agreement, or failing that, 2 years after the formal notification. This is the case unless the leaving state and the European Council agree to extend this period. The withdrawal agreement has to be negotiated by the European Commission in accordance with guidelines established for that purpose by the European Council, made up of the heads of the member states, excluding the departing state. All of this is an example of the ways in which the European Union is an entity based on law.